Good morning and welcome to the Kenney Sams Business Litigation webinar series. My name is Matt Welnicki.
And I'm Anthony Fioravanti.
And we're glad you could join us this morning. To give you a brief overview of what we're going to cover today and in the other webinars we're presenting, today we're going to go over an overview of litigation, claims, lawsuits, things businesses might face when they're doing business. In future webinars, we're going to cover topics such as insurance, discovery, the various phases of the litigation, and some common tips and tactics on how to get the best results in that litigation. Overall, our goal is to try to demystify the litigation process and some of the things you might encounter as a business. And if you gain nothing else from these brief 30-minute webinars, we hope that you'll find to take all litigation, all claims, very important. Now, as we go through some of the topics today and in the future sessions, we want you to keep one thing in mind. Try to ask yourself why we're covering these topics, why we're going over various things, and how it could impact you. It's very important in litigation, like many other things in business, to have a game plan from the start. Sure, things will change as litigation or claims progress, but it's important to have a game plan, know why you're doing things at certain phases. You want to be playing chess while your competitors are playing checkers.
So we've been talking about claims, lawsuits, litigation, and it's important to distinguish what those things mean. A claim is very different from a lawsuit. A claim will be asserted in a lawsuit, but oftentimes claims arise well before the litigation or formal lawsuit process plays out. So what is a claim? It's, in its simplest form, a claim is simply the assertion of a legal right for which you or your business may be responsible. And the claim will often arise sometimes years before there is any formal litigation or a lawsuit about that particular claim. It is important to take all claims seriously, even though there is no formal legal process involved yet, and it's a very preliminary step in the process. Taking claims seriously early on in the process and involving legal counsel to assist you in evaluating that claim is it's very important because you can develop that strategy that Matt was talking about early on in the process. And ignoring claims can just lead to lawsuits. A claim typically will not go away on its own. And if you take it seriously early in the process, you can typically get to a resolution before there is a formal legal proceeding, a lawsuit that is filed. Claims are also important in taking them seriously early on because there are certain reporting requirements that you or your business may have. For instance, if you have an insurance policy that may cover that particular claim, it's important to put that insurance carrier on notice. Hey, I've received a claim here that you may be responsible for, and I'm just letting you know that it exists. Perhaps nothing more will be done with that claim, but it's important to put the insurer on notice at the outset because you don't want the insurer to say somewhere down the line, some years later, when it does ripen to a lawsuit, well, you heard about this 3 years ago, and I'm only hearing about it now. So, and that may present issues for you in obtaining insurance coverage for that claim. Additionally, there may be recording requirements to your partners in the business or even to shareholders in your business. The folks that are involved in the business need to know what's going on and particularly need to know what claims have been asserted against the company so that adequate steps can be taken to protect the company against the claim and protect the company's interests. Now, what does a claim look like? Well, it can be either formal or very informal. For instance, if you are a property owner and you receive an email, hey, I slipped on some ice outside of your property and hurt my back. That's a claim. That's the assertion of a legal right. I was on your property for which you are legally responsible. I slipped and I incurred an injury. Very informal, but that's the type of claim that you want to take seriously and put your insurer on notice of. A claim, even in the business context, a claim could come in via email and be very informal. Hey, we have a contract. You're supposed to deliver this good to me. by X date and you're late. That's the assertion of a claim. Conversely, a claim can be very formal in a formal demand letter with prepared by an attorney that has all the bells and whistles saying this is a claim, this is clearly a claim. But it's important that each of those, whether formal or informal, are both treated similarly.
And Anthony did a very nice job of speaking about what to do when you receive a claim. Keep in mind too, as we go through these topics, that there are very many times when you'll have a claim of your own as a business. And you need to recognize when claims or possible legal rights arise, because you may have contractual requirements, and we'll get to that in a little bit today and in other webinars. But if you have a claim or the right to bring a claim, sometimes you need to assert it in a timely manner. Construction contracts are particularly fond of including requirements that you give claims a certain amount of notice to the other side, or they're waived forever. So we just talked about claims. Now we're going to talk a little bit about lawsuits. Lawsuits are easier to recognize. They obviously involve courts. You'll get a complaint, a summons served on you formally or sometimes less formally, but they're more easily recognizable. But just like claims, they shouldn't be ignored. The minute you receive a lawsuit as a business, you should be taking a look at it, understanding what exactly is being alleged, what is not being alleged. As Anthony talked about claims, when you get that lawsuit, you should look back to see if there was actually a claim that preceded the lawsuit. In some instances, if the claim was not made before the lawsuit or a certain demand letter or other prerequisites were not met, you may have an easy defense right at the outset. And there are various types of lawsuits you may receive. We're going to be going over those in a few minutes, and there's many different forums that the lawsuit may take place in: federal court, state court, small claims court. So you have to take a look at exactly what you're dealing with right from the outset. And there's a third quasi-claim, quasi-lawsuit, and that's arbitration. Many businesses get involved in arbitration by virtue of having a contract that requires for arbitration or possibly mediation at the outset before any lawsuit could be brought. That's something that's important to recognize as well.
And just one word on arbitration. Arbitration and mediation are frequently talked about together. And oftentimes I have clients that don't quite understand the difference between the arbitration process versus the mediation process. Arbitration is very similar to a court process, except it's in a private setting. So there will be a demand for arbitration setting out the various claims that the party may have. That demand needs to be answered. There is essentially a private judge that is retained by the parties to decide the dispute, and that private judge, the arbitrator, the decision that arbitrator reaches at the end of the process becomes binding on the parties. So it's really a substitute for the formal litigation process. Mediation is very different. Mediation is a voluntary process that the parties to a claim can get involved in. They hire a third-party mediator, and the purpose of that is to see if the parties can reach a settlement of the claim or claims rather than proceeding through the arbitration or formal litigation process. It's important to note that mediation is a non-binding process. So just because you decide to go to mediation does not mean you have to accept whatever settlement negotiations that mediation process produces. At the end of the day in mediation, you can say, you know what, this doesn't work for me. I'm not agreeing to this proposed resolution. So mediation is voluntary, non-binding, whereas arbitration, it is a voluntary process that the parties have to agree to involve themselves in. But at the end of the day, the arbitration decision is binding on the party. So I just wanted to point that out.
That's great. So there are three basic types of litigation matters that a business might encounter. The first one would be tort claims. The second one would be contract claims. And the third would be regulatory and enforcement claims. Now, there are other types as well. We're leaving out criminal for now. That's something that should be taken obviously very seriously. But less frequently, your business will be encountering those types of situations. This first category, torts, is something you may think of as a slip and fall or personal injury or product liability matter, but torts can encompass a whole bunch of other different types of business claims. Business defamation, disputes between partnerships, really anything where one party is trying to recover and be made whole for damage that was done to them. Now, this will be different than contracts in the sense that there's not a piece of paper in front of you setting forth the rights of the parties. Typically in a tort claim, you're looking to either statutes or common law or other avenues to determine what the parties' rights are. And it's important to figure out at the outset of any litigation or claim brought against you as to what the nature of the tort claim is, because different tort claims may allow for different measures of damages. And damages is the end result of any litigation or claim, so it's something to keep in mind right from the outset. You don't want to wait till the last minute, till the end of a claim or the end of a lawsuit, to try to determine what amount of damages your business could receive or your business might have to pay. So the types of torts that a business might encounter would be someone slipping and falling on your property. It could be if you're a product manufacturer, something goes wrong with the product and a person is injured. It could involve torts brought by employees for employment discrimination, for a wide variety of personal interferences. You may also have misrepresentations, fraud, a wide variety of things ranging from someone being physically injured to someone suffering some sort of less tangible harm.
And in the tort context, when you receive notice, again, when you receive notice of the claim, it's important to put your insurer on notice, because particularly in the tort context, there may very well be insurance coverage available to you or your company that could cover that claim and provide for defense of the claim under the insurance policy. That is typically not true in the contract cases, and so contract is different from tort in that respect, and in several other respects. I mean, with a contract, some people think that they're fairly straightforward disputes because there is a written agreement in most cases that all the parties sign that's supposed to structure the relationship and provide the rights and obligations of each of the parties. However, invariably, the parties have disputes about what the contract actually means and what their obligations actually are, and whether one party followed the terms of the contract and is entitled to relief or didn't. So oftentimes, when there is a breach of contract claim, while it may seem straightforward, they end up in litigation or arbitration because the parties simply have a dispute as to what their rights and obligations are. With respect to damages in the contract case, typically they are set out in the contract. And the basic measure of contract damages is to put the non-breaching party in as good a position as he or she would have been in if the other party didn't breach. It seems straightforward, but oftentimes there are disputes as to what that means in practical terms. There are one category of damages that's frequently excluded in contracts is consequential damages, which are different from direct damages. And it's important, when you're preparing contracts or involved in a litigation involving a contract dispute, to know just what types of damages are available if you're the plaintiff or are not available if you're the defendant. And with respect to consequential damages, if I could just briefly talk about that. Consequential damages are damages that a non-breaching party might suffer that aren't necessarily foreseeable within the context of the contract itself. I think the typical case, let's say you're a product manufacturer and you need a particular widget to manufacture a project, and you have a contract with another company to deliver that widget to you so you can prepare and produce the goods that you then sell to your customers. So you have a contract for this widget and you begin taking orders from your customers, expecting that you'll get the widget and be able to produce your goods. If for some reason you don't receive that widget or there's a problem with it, and you aren't able to produce the goods that you have contracts to sell to your customers, those lost profits can be considered consequential damages, because it's not a direct result of the breach by the widget producer, but it's because you have ancillary contracts with other parties that really give rise to your damages, your lost profits. Sometimes contracts can exclude those types of damages, so it's important to know, what damages are recoverable by you and by the opposing party when you're involved in a contract dispute in litigation.
Great. So we've just covered contracts and we've just covered torts as well. Now, there are situations where you'll be involved in a lawsuit or a claim where there are both contract or tort elements to it. And that's why it's important to understand the distinction between what a tort is versus what a contract is, and all the rights and obligations that go along with that. Everything from damages to whether there's special defenses for contracts. A lot of contracts for businesses are covered by the Uniform Commercial Code, so there'll be special defenses you have to look at. There are different statute of limitations. So understanding the distinction between torts and contracts is important, because sometimes a party will try to disguise a tort claim as a contract claim or vice versa, because they believe they can get a better measure of damages under one type of claim as opposed to the other. So you as a business working with your attorneys needs to look through all of that. And as Anthony mentioned, insurance is always something very important for any business. And when you get in a dispute with your insurance company, that's essentially a contract action. So you have to be mindful of the fact that if you don't do what you're supposed to do during the claims process, you may wind up having both a tort claim and a contract claim, the contract claim being against your own insurer trying to get coverage. And there's also another interplay between tort and contract. In some situations, your contracts will have indemnity provisions for other parties. So take, for example, someone slipping and falling at your place of business. That may have been the fault of a janitorial company or some other third-party contractor, and you have a contract with that third party that provides indemnity for you for things arising out of their conduct. Well, now you have a contract dispute and you have an underlying tort dispute. The measure of damages between what you can recover against your third party versus what the plaintiff can recover against anyone might be different. So it's important from the outset to understand that distinction. Now, the third topic of common claims a business might face would be regulatory or enforcement claims. And that could range from, if you're a product manufacturer, could range from the FDA looking at your products, could also range in the employment context with various state agencies taking a look. The Massachusetts Attorney General has a wide variety of departments that look into business dealings. Hopefully you're not going to be dealing with regulatory concerns, but there can be overlap very frequently between a tort claim, contract claim, and some regulatory actions.
Yeah, one very frequent area of overlap on the regulatory enforcement and contract or tort claims is the employment context. As Matt said, the Massachusetts Attorney General has various divisions that are responsible for enforcing various laws, including Massachusetts employment laws. So, for instance, you could, as an employer, have a claim by an employee or a group of employees for unpaid compensation, whether it's wages or in the construction context, prevailing wage. So you could have a private lawsuit by those individuals asserting a right to payment, and at the same time, the Attorney Generals could initiate a regulatory enforcement action against your company to see if you are complying with the employment laws of the Commonwealth. So that's one area where there can be overlap between the regulatory enforcement aspect and the litigation, private dispute between an individual and your business.
And certainly because the different state agencies or federal agencies might be parties. A municipality might be a party to your dispute if you're doing business with the state or a town. Because that's a possibility, you also have to be mindful of the use of regulatory actions to sort of gain an upper hand on your business when you're dealing with the other side being a municipality or a different state or federal agency.
Yeah. Now, in addition to tort claims, contract claims, regulatory actions, we thought it would be useful to talk about Massachusetts General Laws, Chapter 93A. And anyone who's been in business for any period of time in the Commonwealth is probably familiar with Chapter 93A. Chapter 93A is the Massachusetts Consumer Protection Act. And although it's the Consumer Protection Act, in addition to protecting consumers in their relationships with businesses, it also protects businesses in their relationships with other businesses. So it can apply in the consumer to business context and also in the business to business context. Most simply, Chapter 93A prohibits unfair or deceptive acts or practices in the context of any business in the Commonwealth. What that means in precise terms is relatively hard to define. The courts have struggled with it. Parties have struggled with it. But generally, it means if a business engages in some practice that seems unfair, you advertise a particular price for a product, and then when you get to the store, it's sold for some amount above that. That's an unfair act, and people can recognize that. Or that's also deceptive, right? So you entice people with a certain price and then deceive them by selling them something else. In the business-to-business context, it often comes up where one party, even if there is a contract, tries to extract a little bit more from the other party than they're entitled to. So that's, generally speaking, 93A, it will govern your relationships with, if you're a consumer-facing company, it will govern your relationships with consumers. But it, as a business-to-business relationship, it governs that as well. And Matt, do you want to talk about how these 93A claims often arise?
Yes, and we're going to be devoting a whole webinar on 93A claims, but this is an excellent example of paying attention to claims when they come in, because very often you will see a 93A demand letter. Indeed, it's a prerequisite for individuals to bring a 93A claim against a business. You will see that demand letter come in, and that's something that you absolutely have to pay attention to. You want to do a proper response right from the get-go, not only to protect your rights later on in defending against the 93A claim in a lawsuit, but also it's your first opportunity to develop a good strategy to how you're going to handle the claim from start to finish. And as Anthony mentioned, 93A courts wrestle with it, but it's sort of a hybrid between a tort and a contract claim. In fact, you could prevail on a fraud claim against your business, but still be subject to a 93A claim as litigation goes on. And while we're talking about a special statute for unfair deceptive business acts and practices, it's probably important to talk about the different venues you might find yourself in during litigation. And one of them is the Massachusetts Business Litigation Session. It's a special court, part of the Superior Court in Massachusetts, that is set up in Suffolk. And the judges there tend to stick to the session a little bit more than other judges in the Superior Court. Those judges focus on business matters. It's a very positive venue to be in for businesses, but of course it's not going to cover every type of dispute a business might have. It focuses more on business-related torts or contract claims, as opposed to a slip and fall that might just happen to happen against the business. And Anthony would like to talk about a few other the different venues you might find yourself in.
Sure. So the business litigation session that Matt talked about is a session of the Superior Court. It's a special session only in Suffolk. There are generally two judges that kind of alternate within that session. In the other Superior Courts in Massachusetts, the State Superior Court in Massachusetts, the judges rotate on a cycle, and you may get 2, 3, 4 different judges that may handle a particular piece of litigation over the course of the case. So there in Massachusetts state courts, there's the Superior Court, which is where most disputes are typically covered, and that has jurisdiction over cases. Is it $50,000? I know they recently
$50,000.
So $50,000 in dispute or more will be in the state Superior Court. Below that $50,000 threshold is the Massachusetts State District Court. So that handles smaller disputes. It's a lot busier of a court. You won't get as much attention from the judge as you may in the Superior Court session, and certainly not as much as you would in the business litigation session. And then below the District Court, there's the Small Claims Court, which you may find yourself in But we generally don't handle small claims matters and less frequently handle district court matters, though it happens from time to time. In addition to the Massachusetts state courts with the small claims district and superior court, there is the United States District Court for the District of Massachusetts. That's a federal court, a federal forum, as opposed to a state forum. And the court that you end up in will depend on the facts and circumstances of your dispute, because each of those courts has a specific jurisdiction and can only hear certain types of cases, like I mentioned with the Superior Court, where it's got to be a dispute over $50,000 or more. Sometimes you have the opportunity to select your court. So jurisdiction may be available both in the state Superior Court, but also in the federal district court. And when you're developing your litigation strategy, when a claim comes in, giving thought and consideration to what is the best forum for this dispute, where will you gain the most advantage, is very important and something to think about if there is if there is jurisdiction in multiple courts.
And we will have an entire webinar on some litigation strategies, but as Anthony pointed out, determining what court you're in early on could be very important to your case. Same thing with determining whether you want a judge or jury to decide the matter, whether you want to go forward with an arbitration, if you have that right pursuant to contract, or you want to be in front of the jury in superior court or a federal court if that's a possibility. So those are considerations you need to give to the claim or litigation when it first comes in. There'll be other considerations as well. We'll be discussing some of those in future webinars as well. But again, just want to bring you back to what we talked about at the beginning, which is if you find yourself or your business faced with a claim or lawsuit, the most important thing you can do is pay attention to it. You should try to understand the documents you receive. You should seek out competent legal counsel right from the start. You should take the matter very, very seriously, because the last thing you want to do is not only have a claim escalate into a larger lawsuit or a small lawsuit escalating into a big lawsuit. You want to jump on top of any claim or lawsuit so you can develop the strategy. You can develop the game plan. You can ask those questions about, why am I going to do something? Obviously, things will change, as we mentioned, but having that game plan from the start is very important. Now, in future webinars, we're going to talk a little bit more about insurance, a little bit more about about strategies when you initially get the complaint. We'll also talk more about the different phases of litigation. Common question we're often asked as lawyers is, how long is this going to take? How expensive is this going to be? Well, there's a long list of factors that go into that, ranging from which courts you select, to what the other side does, to whether it's a contract or tort claim, whether it's arbitration. So there's a number of things. So that's not an easy question for us to answer. And we always hate answering that question. It's almost as bad as the question as, give me a percentage on my likelihood of success. But as we go through these webinars, we'll talk more about the different factors that go into it. We'll demystify some of the steps that you will see. And we'll try to give you a better understanding of business litigation here in Massachusetts. I want to thank you very much for joining us this morning. We look forward to seeing you again.